Hello, Salamat Sizbi, Zdravstvuyte. On behalf of the British-Kazakh Society, it's a pleasure to welcome you today to this webinar titled World-Class Dispute Resolution Services in Central Asia. On housekeeping, the webinar will be video recorded and available on the BKS web. A simultaneous interpretation into Russian. There should be a language choice button at the base of your screen, so please select your appropriate language. Today, we are delighted to have the Chief Executive of the AIFC Court and the Astana International Arbitration Center, plus two of his colleagues. And also, we're extremely pleased to have Rashid Gaissin back again as our moderator for today's session. So with that, just brief introduction, over to you, Rashid.
Yeah, hi everyone. It's a great pleasure to be a moderator of today's discussion. And we really hope to have it as a discussion today. And as David explained, we have three distinguished speakers today. And I will just go through one by one, introducing all of them now. So first one is Mr. Christopher Campbell Holt, Registrar and Chief Executive of the AIFC Court and International Arbitration Center. Christopher is Registrar and Chief Executive, and he's also an enforcement judge of the AIFC Court. And he's responsible for the day-to-day management and administration of the court and the International Arbitration Center, and case management of both litigation and alternative dispute resolution as delegated by the Chief Justice and Chairman. And Christopher was from the very beginning involved in the establishment of the AIFC Court and IAC. He is also a member of AIFC Legal Advisory Council, which reviews and approves AIFC law. And he is also a member of a working group on judicial and legal reforms of the Supreme Council of Reforms of the Office of the President of the Republic of Kazakhstan. And Christopher is also a member of International Council of the Supreme Court of the Republic of Kazakhstan, which advises on reform of the Kazakh courts and dispute resolution. Christopher has many years of experience working in different jurisdictions, including UK, US, Middle East, and Central Asia. And prior to his position in Kazakhstan, Christopher was a registrar at an international financial center, commercial court, and ADR, Alternative Dispute Resolution Center, in Qatar, under the presidency of Lord Wolf, the former Lord Chief Justice of England and Wales. And Christopher also worked at Norton Rose Fulbright, international law firm. And he also worked in Middle East with the international law firm Covington and Burling in Doha, Qatar. So I think we probably stop here for now, unless, David, you think it's appropriate for me to introduce two other speakers as well now.
It's in your hands, Rashid.
Excellent. So if you don't mind, Alexander and Ilya, I don't want to hold you and not to sort of introducing you properly. So if it's okay, I will start with Ilya. Dr. Ilya Rachkov, he's a member of IAC panel of arbitrators and mediators. Ilya is a partner at the law firm Nektorov, Savaliev Partners in Moscow, Russia. And he's also a professor of international economic law at the Moscow State Institute of International Relationships. And main focus of Ilya's practice is dispute resolution, arbitration, and international trade law. Our third speaker is Alexander Korobeynikov, partner at Baker McKenzie, and he's also a member of IAC arbitrator panel. And Alexander is specializing in dispute resolution, energy and natural resources, and antitrust and competition issues. So I think we have our brief introductions by now. So I guess now we can move towards a few words from Chris, I guess, and then the film. and then we'll have questions and answers and proper discussion, hopefully. Thank you.
All right, thank you very much, Rashid. And I'd like to start by warmly thanking the British-Kazakh Society, and in particular David Skeels, for his kindness in inviting us to participate in this important webinar for not just for British-Kazakh Society, but for us, also for us in Kazakhstan at the AIFC Court and IAC and the wider AIFC. I'd like to note thanks also from the AIFC Court and IAC to Steve Bourne, who currently works in the AIFC and formerly was at City UK. It's because of him that we were kindly introduced to David Skeels. So thanks to him for that. And thanks, of course, to Rashid, our moderator, and to two of our excellent, most distinguished and most experienced IAC arbitrator panel members, Dr. Ilya Rachkov and Mr. Alexander Korobyanikov, who both have been extremely supportive of every initiative that we've launched at the AIFC Court and IAC for some years now. Very quickly, by way of background on the Court and IAC, for all of the participants who are not perhaps so aware or informed of what we do in Kazakhstan at the AIFC Court and IAC, we really believe that our services are unique. Unique for Central Asia, but unique in other ways as well. And the elements of that, the features of that, I hope will come out during the course of the questions and answers. But just very briefly, as by way of background, Lord Wolf and myself were invited by the governor of the AIFC, Dr. Karik Kalembetov, to come to Kazakhstan in early 2017. And we were given advisory roles to help advise on the establishment of the AIFC Court and the IAC, and to some extent with other people, specifically Michael Blair QC, I hope you won't mind me mentioning him, the chairman of the AIFC Legal Advisory Council, to assist with the creation and development of the so-called common law that applies in the AIFC acting law. Lord Wolf subsequently became the Chief Justice, the first Chief Justice of the AIFC Courts, with effect from the 1st of January 2018, along with, I believe at the time, 8 judges, all of whom come from the English common law background, a mixture of very senior, distinguished and internationally renowned and respected judges, plus some senior barristers with judicial or international arbitration and other dispute resolution experience, not just in England and Wales, but throughout the world. Barbara Doman QC from Blackstone Chambers in London was appointed as the chairman of the IAC, the International Arbitration Centre, again with effect from the 1st of January 2018, and I became the registrar and chief executive of both the court and the IAC from the same time. Since then, I can tell you that as of today, both the court and IAC combined have successfully resolved to completion a total of 418 cases. This is well and truly above what we really expected to have achieved at this stage of our development, as we now are into the second quarter of just the 4th year of our operations. Those cases have consisted mostly, I think, of contractual disputes, non-payments elements in particular, finance matters, land, property matters, some employment disputes, but chiefly contractual disputes, particularly and increasingly finance and construction and engineering focused. Mediation has proven to be extremely popular so far at the IAC, and we're satisfied, we're happy with that. It seems to be similar to some initiatives being rolled out in the local courts of Kazakhstan. I should set out that we are completely 100% independent at the court and IAC, with impartiality and incorruptibility being absolutely critical to the services that we provide. Parties in the disputes, the 418 disputes so far, have come from the United Kingdom. They've come from Kazakhstan, Russia, China, Turkey, Poland, Azerbaijan, a number of other countries, and throughout most of the regions. I think it's 11 or 12 regions now throughout the whole territory of Kazakhstan. So we're really getting wide coverage and traction and interest and recognition for our work. 259 lawyers have now registered at the AIFC Court for rights of audience. I put that out there because we want to encourage more people, particularly from London, to sign up for rights of audience or apply for rights of audience at our court. The lawyers have come from 27 jurisdictions throughout the world, 25 countries, 3 jurisdictions from within the USA, and that covers lawyers from Latin America, I just said the USA, the United Kingdom, throughout Europe, Africa, Asia, Central Asia, Australia, New Zealand, really the whole world. So we're very pleased with that encouraging sign of recognition and interest and user function for our facility. We are completely 100% online during COVID-19. We do have world-class physical premises in the Sultan, the capital city of Kazakhstan. We're very proud of those. We reckon that those and believe that those would rival the physical premises of any dispute resolution center anywhere around the world. And we have the latest digital technology. We apply e-justice, which is a case management system, which we launched in February 2019 with the support and development support of a company based in Singapore. We also use video hearing technology for pre-trial and trial hearings at this stage. We've been included in more than 4,000 business contracts for dispute resolution as the #1 choice for commercial dispute resolution in this Central Asia region, including with companies such as Chevron, Tengiz Chevroil, who have really set the benchmark, if you like, for other companies, particularly in the oil and gas sector in Kazakhstan and the Central Asia region. In addition, very quickly, out of interest, the added value that we bring to Kazakhstan, Central Asia, and perhaps the world in some smaller and diluted form is training and development. We have now trained more than 2,000 Kazakh national lawyers and business people on the common law. How does the common law work? Key principles of commercial law as it applies within the AIFC legal regime, and also specifically, obviously for our purposes at the AIFC Court and IAC, dispute resolution skills, online and in-person advocacy skills, arbitration, counsel and arbitrator skills, mediator skills with an accredited qualification from an institution based in London with international reach. So all in all, we believe we're making tremendous progress very quickly, ahead of time. We're enormously ambitious, as always, not just us at the AIFC Court and the IAC, but the whole of the AIFC, in fact, the whole of Kazakhstan, as I'm sure the members of the British-Kazakh Society all know by now. And we're very excited about the future, and we hope that you will all be coming along with us on this journey as we continue to progress our plans in the coming years. Thank you.
Right. I think we're done with the film. I think we could all read and had the excellent opportunity to see the slides. And I think some of them, they already kind of reinforce the message which Chris delivered 5 minutes ago about the number of cases, about the milestones. And I guess my first question to Chris and two other speakers would be on how they view, and obviously for Chris, who's official within the court, but from our two practitioners, would be interesting to see the vision of both AIFC Court and IAC sort of vision, and what the key objectives they think should be at this stage of development. Chris, if you don't mind, we'll start with you and then move to Alexander and Ilya.
Thank you very much, Rashid. Very quickly, in answer to the question, as I said before in my introductory remarks, the AIFC Court and IAC share a common goal, and that is to be recognised as the #1 choice for commercial dispute resolution for the whole Central Asia region, not just for the AIFC or Kazakhstan, but for the whole Central Asia region. We believe that we're making very important footprints and impact already at this early stage of our development, that we are a long way along the road of achieving that, despite the efforts of some other countries with their initiatives as well. Indeed, we're seeking cooperation and partnership with those other countries, not competition. The end of the video highlighted some of the key objectives that we're focused on a very, very high level. Of course, we have very detailed plans in place and we're implementing those right now. But cases, of course, we're working on various initiatives to increase quickly the number of cases coming both to the court and to arbitration. Secondly, we're rolling out new enforcement initiatives, and I'm sure we'll come on to enforcement a bit later in the details of that, but we're working on more international arrangements to make that as reliable as possible internationally. Further services roll out every year. We make sure that we are rolling out new services, and those will be launched in due course throughout the course of this year, and further international recognition for all of our efforts, because we want this AIFC Court and IAC and the AIFC to be here for a very long time. We want it to be trusted, for it to give confidence for investment to come to Kazakhstan, so that if investors invest, they are persuaded, they believe, and it is actually true in practice that they have absolute protection if anything goes wrong during the course of their business relations.
Thank you very much. Alexander, Ilya, would you like to add probably anything at this stage, or you agree with everything and we can move on to some other questions?
Yeah, first of all, thank you for this opportunity to be here. That's my pleasure, and I always like to use the opportunity to share my own pleasure to be a part of AIFC initiative. And first of all, I would like to say that AIFC Court and IAFC Arbitration Center have very great start. And what was already achieved by these two institutions are remarkable, take into account that official start was only a bit more than 3 years ago, starting from 1st January to 2018, and the number of cases which these two institutions already considered are much more than I expected from the beginning. Therefore, like, the first objective is just to continue as the same rate as you are doing right now. The second thing, and that was already mentioned by Chris, that AIFC Court and Arbitration Institution should use this unique opportunity to become a hub for the settlement of commercial disputes between different parts of Eurasia, or even different parts of the world. Because Kazakhstan has this unique geographical location between biggest market players like China, Europe, Russia, and India as well, Middle East, and Kazakhstan like supposed to be the center of investments, of movements of money and goods between these different market players. Therefore, AIFC as I understand, is planning to be, and I'm quite sure that it will be the hub for the settlement of disputes between investors and companies from different countries, not only in Central Asia region, but also from China, from Russia, and all that features which AIFC already provides to investors will definitely support this intention.
Thank you, thank you. So I think we now slowly move into the jurisdiction, and I guess I won't spend too much time on arbitration, which is obviously common for many other kind of arbitration centers. You know, you choose it and you do it. But I think AIFC Court jurisdiction is far more interesting, because I think that's something which sometimes may be underestimated by potential players in Kazakhstan, including their in-house lawyers, including their external legal advisors. So I suggest we probably start now with Ilya and move to Chris and Alexander if they wish to comment, please, on jurisdiction of the court.
Rashid, thank you so much. I would prefer probably to give the floor to Chris, because that's his daily bread, so to say. I'm happy to comment on the jurisdiction at a later stage.
Okay, let's start with Chris and then come back to you, yeah?
Thank you.
Just to make sure that you comment today, yeah?
All right, thank you very much, Rashid and Ilya. So the jurisdiction is provided very clearly in Article 13 of the AIFC Constitutional Statute 2015, and also in Regulation 26 of the AIFC Court Regulations 2018. And the jurisdiction, let's start with what it is not. It is not for criminal matter disputes. It is not for so-called administrative disputes, but let's not confuse how we define or understand administrative disputes in Kazakhstan from how we would perhaps in England and Wales and other parts of the world. It does not mean that the AIFC Court cannot review the decisions administratively, but on a limited way, of AIFC bodies. It can and it will. The jurisdiction is in effect for commercial matters, so contractual matters, for operations involving AIFC participants or registered companies or individuals within the AIFC. And we also have opt-in jurisdiction, which is where the parties to a dispute can agree in writing at any stage, pre or during dispute or post-dispute, to use the AIFC Court for dispute resolution. So that, in a very high level, is the jurisdiction. It is being tested, I should say, ultimately, as provided by the Court Regulations 2018, the judges themselves decide whether, in every case, it is appropriate, and they will give jurisdiction to the parties for that particular dispute on a case-by-case basis.
Thank you very much. Ilya, would you like to comment, or probably select another question for you?
Yes, thank you. Just a couple of thoughts. I think the jurisdiction of the AIFC Court is not very much different from what the world knows from other examples, like the similar courts in Dubai, in Abu Dhabi, or in Qatar. Clearly, there are some deviations or differences, but all in all, I think it is important for the foreign communities which want to do business with Kazakhstan or in Kazakhstan to have a reliable dispute resolution forum based on the rules of the game familiar to them. And because many contracts are drafted based on English law or are largely inspired by English law, it's very natural to circumscribe the jurisdiction as it is circumscribed now in the constitutional statute and also in the regulations of the AIFC Court. Thank you.
Thank you, Ilya. Alexander, would you like to add anything here, or we can move to next question? Next question. Okay. So I guess, and I've looked at the number of participants today, and I do understand most of them, well, the majority are Kazakh lawyers, or based in Kazakhstan at least. But we do also have some foreign delegates as well. So the question, my next question will be for example, a Kazakh company wants to use the AIFC Court or arbitration. And for example, it's not with another sort of commercial party, another Kazakh company or foreign, but with a Kazakh state entity. So basically Kazakh state-owned enterprise. So how would you see and what sort of instances it's possible, and what this Kazakh company, private company, should do to make sure that they will end up not in a Kazakh court, but at AIFC court or arbitration? So I guess anyone can start, and then we can sort of move around, yeah? Maybe Alexander, we can start with you if you don't mind.
Of course. Thank you, Rashid. And I would say that this is one of the most popular questions that I have been asked during my practice by our clients. That's whether private companies, private investors can use AIFC International Arbitration Center as a venue for settlement of their dispute with state-owned companies. And the answer to this question is yes. And in addition to that, I would also like to mention that last year, the government also adopted a resolution which actually recommended state-owned companies to use AIFC Court and Arbitration Center as a venue for the settlement of their disputes with local and foreign investors. Therefore, state-owned companies are open to consider this option, and even most of them arbitration center. And in our practice, when our clients propose to have the arbitration clause with the reference to AIFC Arbitration Center, we have never had any significant objections from the state party. Therefore, the answer to your question is just propose that and use the model arbitration clauses, which is listed in AIFC International Arbitration Center website. There are model arbitration clauses in both languages, in Russian and English. Therefore, just follow these templates, and ultimately you will end up in International Arbitration Center. And the biggest feature, and I think the most important feature of that International Arbitration Center, that its award will be enforced not via a local Kazakhstani court, but via AIFC court, which is, as Chris already mentioned, is fully independent from the Kazakhstani ordinary court system. And
I think we'll come back to enforcement, Alexander. Now I know that if the state-owned enterprise is somehow objecting to arbitration and the IAFC, I would definitely refer to Alexander Korobeinikov and say, look, you have to think about it, you have to use it. And I do know, Chris, that you obviously had discussions and MOU with Chevron and Tengiz Chevroil on the use of model clause, arbitration clause. So I wonder whether you have anything similar with, let's say, Samruk Kazyna Group, Bayteria Group, and other sort of larger state-owned companies.
Thank you, Rashid. Yes is the answer. I understand there are some contracts. I can't quote the number for you right now, but there's been a profound campaign, if you like, not just by us, but by the government of Kazakhstan, by senior people within the AIFC authority management team and others, to really encourage all companies within Kazakhstan, not just within Kazakhstan, but throughout Central Asia especially, to include both or either the AIFC Court or IAC in their contract dispute resolution clauses. You mentioned Tengiz Chevroil. That was for a very considerable number of cases. We're grateful to our colleagues, Alexander and Ilya, for recommending to their clients to put us in contracts, but it's not just us, it's very many people are a part of this effort. I would like to just add, though, if I may, that we currently have ongoing cases involving the state of Kazakhstan. Of course, I can't say any more than that, but we're now at the stage where it's not just private parties, it is the state being involved in dispute resolution as well, which was, of course, part of our long-term objective to be available for everyone on equal terms.
Excellent, thank you. Once you were speaking, Chris, I started thinking about our own standard model legal services agreement, or whatever services agreement, audit or whatever, we sign with our clients. And I'm not sure we use AIFC arbitration for now, but that's probably something to be discussed with our in-house lawyers, both in Kazakhstan and more importantly, outside of Kazakhstan. So
may I suggest that they do?
Absolutely, absolutely. Otherwise, how can we advertise it without using ourselves, right? So next question we have online. So I have a list, obviously, of prepared questions, but now we have Gordon Nardell, QC, and his question is, again, okay, you can see it in questions and answers section, but I will read it out loudly just in case someone do not have access. So has the court ever, I mean AIFC court obviously, had to consider an objection by a state-owned enterprise to jurisdiction over a contract claim on the basis that the matter is administrative in nature? So in other words, I think we have a situation which Alexander described when state-owned enterprise originally agreed in a contract, and then there is a dispute, and then there is a objection to the claim on the basis that it's a pure administrative in nature and it cannot be tried by court. So
the answer is very simple, no.
I wonder whether it's Chris probably will start with you, yeah?
The answer is no, we have not.
Okay, good. So I hope it's a satisfying answer, and we move to our next question. So I think we now talk a lot about ADI, alternative dispute resolution, and what is the judicial mediation and how does it work at the AIFC court? Is it compulsory, by the way?
Would you like me to answer, Rashid?
Chris, I think we can start with you and then move to Ilya, and Alexander might add if he wants to, obviously.
Thank you. Okay, so judicial mediation was an innovation, if you like, that we introduced to the court after we had established the court. And as I said in my opening remarks, that we are continually launching, developing new products, if you like, new services to improve and enhance the user friendliness, if you like, of our services at both the court and IAC for quick and cost-effective dispute resolution on terms we hope parties will be satisfied, at least procedurally. And the judicial mediation was brought in and launched, I think, sometime in 2019, in our second year of operation. We launched it in Sultan, Kazakhstan, with an opening launch event as usual at that time, pre-COVID-19. And the whole point was to offer mediation services, not just at the arbitration centre, but also at the court as a first point of call. It is not compulsory at all. Everything we do at the AIFC Court and IAC, within reason, is a platform of opportunities. It's an option, an offering for parties to decide for themselves. So if the parties wish to use judicial mediation, then they can do so. If they don't, they can go quite rightly straight to the special fast track procedure of our small claims division, or straight to the other first instance court, and when necessary, apply for permission to appeal to the Court of Appeal in the usual way that you'd expect with an English common law system. Judicial mediation, I think we all know what it is, but just to highlight it at a high level, it is when a judge, a single judge, would be asked to consider resolving the dispute as a first pointer in the court on a mediation basis, and subject to that judge giving assisting the parties with a mediation settlement, then that judge would not be able to be the judge on any further proceedings at the court. But we have not tested it yet in practice. We found that it's not been a part, as far as we're aware, through our surveying and checking with the community here, it's not been a part of contracts in the dispute resolution clause. But what typically is in the dispute resolution clause, and our panel members are better placed than me perhaps to advise on this, but is that there would be negotiations to start with. And then if those are unsuccessful, the parties would logically move on to either arbitration or proceedings at the court.
Thank you. Any comments from Alexander or Ilya? Okay.
I have one. I have one
please,
comment, perhaps, just to remind the audience of what mediation is about, or why did it emerge at all. I think mediation is very demanded in the jurisdictions where the access to justice is relatively high. For instance, in order to litigate before the High Court of England and Wales, you have to spend a lot of money on the lawyers, and you have to wait, etc. So that this is quite a headache to embark on a litigation before state courts in many countries. So mediation is a more successful tool to settle disputes, unless the level of hostility, I would say, reached a certain degree. Mediation is less adversarial, so you have, I think, better chances to settle a dispute. And also there is a perception, whether it is right or wrong, that Asian countries, and I think Kazakhstan can be regarded as an Asian and European, i.e. Eurasian country, are more inclined to solve their disputes by mediation rather than to litigate for years and not come to an indefinite result even within a year or so. Thank you.
Thank you, Ilya. I think that was very, very good additional comment. And we have a couple of questions online now. The question from John Travisy. How many, I think it's for Chris, but maybe some other speakers would want to add. So the question is, how many cases have been resolved against Republic of Kazakhstan, and have those awards been met?
Thank you for the question. As I mentioned a moment ago, we have ongoing cases involving the state of Kazakhstan. None of those have been resolved to final resolution yet. So we're at the stage of watch this case and see. We'll certainly be informing the public if it's appropriate at the time. But I would like to say that I know you're coming on, I think you're coming on, Rashid, later to enforcement as a topic, but I can say very quickly now, we do have step-by-step procedures in place, separate procedures for enforcement against private assets and then again against state assets within the territory, the entire territory of Kazakhstan, not just within the AIFC, but the entire territory of the Republic of Kazakhstan. So we do have procedures in place to assist with swift and cost-effective enforcement of decisions. And if you come onto it later, we'll be very happy to give one or two examples of how we've done that in practice so far against private assets.
Excellent, excellent. I'm sure it's not about Mr. Stati and his famous matter being tried at the AIFC court or whatsoever. So I guess it's another very interesting case. But we have another question. So if you don't mind, we'll just move to another question which we got online from Kujan Mehrabi. So I guess that's for all three speakers. Would the AIFC court hear claims in tort, claims involving commercial fraud, tracing claims in trust, and apply remedies where there has been a breach of trust or a fiduciary duty? So anyone wants to tackle this? Claims in tort.
Shall I offer? I think the answer is, some of this is still yet to be tested in practice, but the answer at a high level I would say is yes. The court is open to all of these. I couldn't hear all of the areas of law that you were listing. I think there was some problem with the sound, maybe at my end, but I heard tort, commercial fraud, and fiduciary duties and trusts. So yes, in principle, the court is open to consider such disputes, and we welcome applications in those areas.
Excellent, thank you, thank you. So I wonder whether, Alexander, Ilya, you had any discussions with your clients on that, or probably not yet. Yeah, I mean, in terms of claims in tort. No, not
yes. Yet. Well, I think I didn't have any such discussion, but the good thing about the AIFC court, as any court applying common law, is that you can combine in your lawsuit both claims. So there is no such doctrine as we know from the Russian procedural law, or I guess also from the Kazakhstani procedural law, competition of claims. So i.e., if you have a contract, you only have to base your claim on a non-performance or improper performance of the contract rather than on tort. So from the English law standpoint, it works perfectly that you might have both claims either as an alternative or concurrently. So that's why the AIFC court, I think, is best suited to hear that type of claims as well.
Okay, Ilya, thank you. I guess next question is against Chris, and obviously Chris knows the answer definitely, but maybe we can try other speakers as well. So the question is from Jandos Uspanov. Where can I see the practice specific cases that you have considered? So I guess we talk about AIFC Court rather than arbitration, because obviously arbitration was confidential. So I guess we talk about AIFC Court. So Alexander, maybe we can move to you and Chris will just confirm where it can be found. Or
yes, thank you. And that's also one of the most popular questions from our clients, whether we can see the practice. And the answer is just go to the website of AIFC Court. I would say that AIFC in whole and AIFC judicial institutions did make great job in digitalization of its activity, and the relevant website is very informative. Therefore, you can find court decisions, court orders, and all other informations about AIFC Court in its website. Chris, just confirm.
Thank you.
Confirmed,
Thank you
but I'd like
much.
to add, if I may, yeah, that's absolutely right. And the website is being redesigned and will be launched at some point during the course of this year. So I hope it's even more user-friendly going forwards. But in terms of arbitration, we haven't yet published any arbitration awards. Of course, the expectation is that those will be confidential and will not be published. However, if the parties agree, and all of them agree, and would ask them to do so, of course, in writing, to publishing some form, if not all of the arbitration award, then we are able to do that under the terms of our arbitration regulations. So we will be discussing in due course, when we believe it's appropriate, with parties and arbitrators in those disputes as to whether they will be consenting to allow us to give some indication, not a library of the A to Z of every single arbitration case. That's just not going to be possible. Of course, I'm sure we'll appreciate that. But it would be a good idea, I think, to be able to showcase at least one or two, so that people, especially people who have not used our facilities before, especially from Kazakhstan and the Central Asia market, can see how it works in practice. Because so far, I can tell you, without revealing any confidentialities, that the arbitration awards that have been drafted so far, which, by the way, are all checked by our chairman, Barbara Doman QC, before they're published, have been absolutely first class, the top international standard. And they have been very thorough in explaining precisely all of the procedural steps that have been taken, and one or two issues that might have come up with the parties in the usual course of arbitration proceedings. So we are working on that. And so again, please watch this case and expect to see some indication of that in our promotional materials on our website soon.
Thank you, Chris. We have another couple of other questions. I know this one is tricky, although the answer is very simple. Again, from Jandos Usmanov, can I file a complaint with the tax authorities? So I know it's one of the favorite Chris questions, and he loves to answer it, but I know that the answer is very short.
So would you like me to answer it?
Please. We've discussed it already. That's why I'm joking about it.
So the court does not currently consider Kazakhstan tax code disputes, and the appropriate place for that, which has already been decided by our Chief Justice and judges, is the local courts of Kazakhstan. However, we are exploring possibilities and potential for our arbitration center to be somehow involved in that process. So if you are, or investors are looking for an alternative to the existing infrastructure, I would say that at this stage they should expect some movement on that in the future.
Excellent, thank you. So not much work for tax lawyers, I'm afraid. Not a good news for Big Four, but okay, let's move on. I think we have.
Sorry, Rashid. Let me probably add something to answer to that question. And I would say that it doesn't mean that AIFC Court is useless for tax lawyers at all, because as of today in Kazakhstan, probably many of our participants know that we have so-called investment agreements with the state or state authorities, which provides for some, which may provide for some tax benefits. And if parties agree in that agreement that all disputes arising out from these agreements will be settled in AIFC Court, and the relevant dispute relates to application of the relevant tax benefits, I believe that that's something that may fall under the jurisdiction of AIFC Court, as a contractual dispute arising out from the investment agreement between the state and the relevant investor. Therefore, that's not like absolutely useless for tax lawyers.
Alexander, but talking about these investment contracts, which is obviously very close to my heart, have you seen as a dispute resolution clause AIFC Court or AIFC arbitration? Because usually, I guess you will, well, 100% you will sign this investment contract with state authorities, and state authorities are very reluctant to do and have any kind of deviation from their standard Kazakh sort of courts decisions, etc. So have you seen any examples of these investment contracts? I mean, recent investment contracts, obviously, on using the AIFC Court?
Yes, the answer is yes. In our practice, we already have several investment agreements, including PPP agreements with state authorities, which refer to AIFC Court or AIFC International Arbitration Center. And right now, one of our clients, one of the biggest investors in Kazakhstan, is in discussion with state authorities to put AIFC dispute resolution clause into the investment contract, and the state authorities is disputing all other provisions, but not this one. Therefore, we are quite
excellent. So I guess you asked for 20 very important things, and one of them was AIFC Court. So they said, okay, let's go for AIFC Court. Yeah. Reject all 19 others. Yeah. Okay. We have a number of other questions. We have a online question from Michael Clayton Jolly. So his question, I guess it's more for Chris, but I'm sure it's relevant to both Alexander and Ilya. Is registration for AIFC rights of audience equally opened to English qualified barristers and solicitors?
The answer is yes, it's absolutely open. When we set up the rights of audience scheme system, it was under the leadership of Lord Wolfe, our first Chief Justice. And as I'm sure all of the participants today, especially from the UK, would expect, there was absolute attention to detail on access to justice. So the procedure is very simple. The details are on the AIFC Court website, and we have registered already a significant number of barristers and solicitors for rights of audience at the AIFC Court. We've also registered a considerable number of Kazakh lawyers who don't have the same regulatory body control, if you like, or monitoring as you would get with regulatory bar boards elsewhere in the world. So we set up a separate system for them to enable them to have access as well. And we provide supplementary training where necessary to support those Kazakh lawyers too.
Good. Excellent, Grace. I think I have a next question, which is directly relevant to what has been discussed about rights of audience. And I guess if you don't mind, I will start with Ilya. So the question is, can a party that has no connection to Kazakhstan bring a claim to the AIFC Court or Arbitration Center? And if so, why should they? So my question is direct question to Ilya, because obviously he's based in Moscow, in Russia. And I wonder how and in what kind of situations he would recommend use of AIFC Court or AIFC arbitration to his clients in Russia.
Yes, thank you, Rashid. Indeed, it makes sense to select a dispute resolution clause which is suitable for the enforcement in the country where the assets are based, on which execution should or may be levied. So for the selection of an appropriate arbitration clause or dispute resolution clause, other decisive factors may be likely may a state court at the seat of arbitration set aside the arbitral award if you opt for arbitration, or how likely will the arbitral award be recognized and enforced in the country where it was rendered and also in other countries. And thus, if a party has no connection whatsoever to Kazakhstan, also in the strange or odd to bring the claim to the AIFC court, but it may be wise to bring a claim to the IAC, to the Arbitration arbitration. A supplier from Azerbaijan or a purchaser from Kyrgyzstan entered into a sale and purchase agreement governed by the UN Vienna Convention on the International Sale of Goods and used an arbitration clause in favor of the IAC or a prorogation clause in favor of the AIFC Court. In the first case, arbitral award rendered by the IAC may be easily recognized and enforced if the debtor has property in the relevant country or of the world, or it may be also enforced both in Kazakhstan in accordance with the enforcement procedure on which Chris may speak at a later stage, or outside on the basis of the New York Convention. As to the judgment of the AIFC Court, again, there are two routes or two avenues for enforcement in Kazakhstan and outside. Thank you.
Excellent, excellent. Alexander, Chris, would you like to add anything, or we have a number of other questions and we have only 8 minutes left? David, we have 8 minutes, right? Okay, so my next question is about digitalization, and Chris already mentioned it briefly. So when the COVID sort of and quarantine and other sort of unpleasant things started all over the world, including Kazakhstan, March last year, I think AIFC generally and AIFC Court and Arbitration were well prepared. So you already mentioned the facilities and online hearings, etc. So the question is whether, obviously, yeah, well, you couldn't expect it that it would happen, but I think, so from what we understand from the film and your presentation, AIFC Court and Arbitration were ready. Second, there was no need for any further regulation or additional legislation, as in some countries where it wasn't sort of 100% prepared and online hearings were unheard of, if I can use that word, before this COVID situation. So, Chris, I wonder how you handle it. I mean, not technically, but in terms of additional legislation, was it required or not? Please.
Thank you, Rashid. I know you have a number of questions and a limited amount of time left, so I'll be very quick, if I may. Firstly, were we ready? Yes, absolutely we were. We had already launched our e-justice system, and we had video technology already partly in use, but not relied upon as much as obviously as it has been since the outbreak of COVID-19. As a business, we moved to remote working immediately, with only 1 or 2 critical staff on operational matters physically in our premises. I'm working from home right now. I'm not in the office, contrary to the corridor you can see in my background. And that has been the case. Health and safety of staff and users has been of paramount importance. So the answer was we were absolutely ready. There was no disruption to our business whatsoever. The case numbers significantly increased, not because of COVID. They're not COVID related, most of our cases, just because that was the trend, the transgression, the path we were on for the development court and IAC. We didn't have to change our rules. When we had the benefit of being a new court and arbitration centre. So we obviously didn't anticipate, I don't think anyone did, COVID-19, how could they? But we did anticipate being able to provide services 100% online, given that we're in Kazakhstan, given that we're expecting to be a part of the attraction of international investment to the AIFC Kazakhstan and the Central Asia region. And we didn't expect everyone to be able to come here at such short notice, as you all know as lawyers, is sometimes required in the proceedings of cases. So our rules did not need to be changed at all. So we have been no disruption, fully operational from the very beginning of the outbreak of COVID-19. And we will continue even after COVID-19 to continue the use of our online services, but we will use the physical premises when it's necessary on a case-by-case basis.
Excellent, excellent. And my quick question, Ilya and Alexander, obviously you both had experience litigating and I guess arbitrating at AIFC. So I wonder whether you had a chance to use online hearings as well. And what's your view and how was it? Tell us.
Alexander, would you like to start?
Yeah, with pleasure. Yeah, that's the comment that I would like to make to Chris' summary of online rules of AIFC. Last year, I had a pleasure to handle one of cases as a sole arbitrator, and I did that only online. And I would personally confirm that there is no any difficulties with handling arbitration case. It was, I would say, quite completed with both parties disputed different issues, but we managed to handle that online with no difficulties at all. Therefore, I can confirm based on my own experience that everything is worked perfectly.
Excellent, thank you. Ilya?
Same from my side, although I didn't have the honor and pleasure to be appointed as an arbitrator in these proceedings yet. I attended a couple of meetings where a much larger number of participants from all over the world participated, and everything went smoothly and without any technical errors on the AIFC court's side. And so the cooperation with the participants to this event went seamless, unless, as I said, there were some troubles on their side. Thank you.
Thank you.
Thanks, Rashid. If I may offer a very quick flavour of
please, but we have 3 minutes only.
Very, very quick. Just to say, I can think of several mediation cases we've helped parties to resolve through mediation, and those disputes have been resolved with parties sitting in their cars in car parks during the first wave, especially, and you could see them sitting in the driver's seat and still presenting their positions satisfactorily and coming to some form of settlement agreement via video, via their mobile phones. So there were no distractions for us.
So now you know what sort of cars every lawyer using AIFC driving, yeah? Okay.
Yeah, they weren't important assets in the dispute.
Okay, so I think we come naturally, and it was touched upon twice during discussion today, enforcement. So how does enforcement of AIFC court decisions happen? So I think, Chris, we can start with you and then move to Alexander and Ilya, if you don't mind.
Thank you, Rashid. Again, in the interest of time, I'll attempt to be very quick. What happens is we've had successful enforcement so far, 100% successful enforcement on all judgments that have needed to be enforced through our mechanism. I'm happy to say that some parties have enforced voluntarily. They've just paid up under the sum due and the judgment or order of the court. But so far, the way it works is we have a step-by-step procedure. It was signed by our first Chief Justice, Lord Wolfe, with the centre here that's responsible for enforcement, the enforcement agents for private enforcements, and also by the Ministry of Justice, Minister Beketeev, the Ministry of Justice in Kazakhstan, with the Ministry of Justice for enforcement against state assets. We haven't tested the state assets enforcement yet, as I mentioned earlier, but we have successfully enforced several times on court judgments and orders in the entire territory of Kazakhstan, not just in the Sultan or Almaty, but throughout the main regions of Kazakhstan. Arbitration awards at the IAC are enforceable throughout the entire territory of Kazakhstan as orders of the AIFC Court. Very quickly, I can tell you, Justice Sir Robin Jacob has been responsible, has done the enforcement of recognition, if you like, and enforcement of those arbitration awards, interim and final arbitration awards so far. And I can tell you that that he, as the judge, has received electronically the application for recognition and enforcement, and within 60 to 90 minutes, he has given his recognition order and a judgment. So it's been enormously quick. And then what I do is immediately instruct my case management team to get on the phone or meet in person if it's appropriate with the enforcement agents, either through the Ministry of Justice or so far through the private bailiffs centre. And we are in contact day and night until the order of the court and judgment of the court is 100% enforced. So far it has been. That's involved freezing bank accounts, seizing assets and the like. So it's been enormously quick. We don't charge the parties, it's free of charge. I should have said that from the outset for all proceedings at the court and IAC until 1st of January next year. And the charges then will only be very, very low anyway, certainly cheaper than other international arbitration centres and common law courts.
Thank you, Chris. I think that was excellent timing. I don't think we have any time left. I think next time we should plan probably for a bit longer session, but I would like to thank our 3 speakers today. And I'm sure if there are any further questions from the audience, you can direct your questions to Chris, Alexander, and Ilya via British-Kazakh Society or directly. And I think, David, you obviously wanted to add something.
Rashid, thank you very much. I would also like to thank everybody for their participation obviously Rashid, Chris, and the panel for their, I'd say, very informative comments. Obviously, from the questions that you've received, the legal community, particularly in Kazakhstan, is very interested in these subjects, but also for, I think, non-lawyers. It's been extremely informative. So thanks for that, and obviously the support from the AIFC Court and the Arbitration Center. So that support is really appreciated. Also, I'd like to thank the people we don't easily see here, Alijan from the BKS for management of a lot of the webinar, together with Asel Muet in the AIFC support team, plus not to forget Igorim, Natalia, and Dinara on the interpretation. So finally, I'd just like to mention a couple of the BKS events which are on our agenda. May the 19th, we have agribusiness webinar with a focus on cereals, and we have Ross Murray as moderator. June the 8th, a very interesting oil, gas and renewables webinar, which is focused on decarbonization in Kazakhstan, a very critical and important topic. And Aida Sidikova from the EBRD will manage that panel. So, and in addition, there will be ongoing events related to the 30 years of Kazakhstan's independence. So with that, I encourage you to view our website and look forward to seeing you all at the next event, and trust you will be joining the BKS if you have not already done so. So with that, keep safe. See you next time. Bye now.
Thank you. Thank you. Bye. Bye,
Thank
everyone.
you. Bye-bye.
Bye-bye.